We are moving forward with establishing a new crime of hate.
Bill C-9, the Combating Hate Act. As I've previously covered, opponents are worried about a change in language from existing speech laws and removing oversight from the Attorney General. Ultimately, critics of the legislation are worried about threats to freedom of speech, pointing to people in the UK being arrested for social media posts.
Is your view that your definition in C9 will not capture anything beyond what is currently captured right now by the hate definition?
The definition was an attempt to codify, and the reason
this is
that
a
there
yes or
was
no question, Minister. Is there at all a lower threshold or a broader net on hate in Canada after C9 if it passes?
My view on the definition question, because the offences I would give a different answer to you for, but on the definition, my view is that it codifies the same behaviour that is there today, and it was meant to provide clearer guidance to law enforcement in the criminal code to apply the existing standard that has been recognised by the Supreme Court.
Because the same arguments that are being used by you and your government to push Bill C9 to protect people against hate, which on the surface sounds incredibly noble, but these arguments are the same arguments that have led to the United Kingdom having police literally knocking on people's doors over their tweets. So what guarantee can you give Canadians that we are not headed down that very road, especially in the context of other priority areas identified by you and your government, such as the Online Harms Act, which was introduced twice, actually, in the last two parliaments?
So this legislation is not identical in kind to the reforms that have been put in place in the UK, and we've actually looked at their experience and see that there are real challenges with how it's played out. For example, we've got a different approach where some jurisdictions around the world have adopted a more blanket glorification that could attract the scrutiny of a liking a Facebook post, for example, and we chose a different path. We instead tried to be very clear that we would not interfere with the charter rights of Canadians to freely express themselves, but at the same time make it easier to lay charges where hate crimes are committed today. To the extent that you think there is a better way to clarify and codify the existing definition, do know that I believe in Parliament, and I don't care which party comes forward with these amendments. If it creates multi-partisan buy-in to codify the test, that's okay by me.
Can you guarantee that if C9 passes, no Canadian will end up being charged because of something they've posted on Twitter or Facebook?
Well, if they commit the crime of willfully promoting hatred against another person.
A crime with a definition that you're changing.
So, but it's possible that they could be convicted for what they willfully promoting hate online today. So certainly I would hope if someone commits a crime in the real world or online that they would face the appropriate criminal penalty if in fact it's captured by the code.